Hello, everyone, and namaskar. My name is Gaurav, and I am a postdoctoral scholar at University of California in Davis. And I take an honor to welcome you all at the event organized by Indian students in the US, supported by India Students Hub. And the event today is about the discussions and insights on intellectual property primer and discussions and careers in intellectual property law for STEM students. And the event is being recorded and being live streamed on Facebook and YouTube page. So at your convenience, you'll be able to access at any point. So with no further delay, we can get started for our program today. And we'll start with a small presentation by our amazing speaker and followed by question and answers. And with that, I hand over the podium for the introduction to Neer.
Okay. Hello, everyone. I am Neer Bharadwaj, a mathematics doctoral candidate at the University of Illinois, Urbana-Champaign, UIUC for short. I got my undergraduate education at IIT Kanpur. I've been here since 2015, and my hometown is Vadodara, India. So now I'll introduce our speaker. Debodhonyaa Sengupta is a patent attorney at Dentons, a global law firm with over 12,000 lawyers and professionals worldwide, with offices in more than 200 locations in 80 countries. Her areas of focus are the chemical, pharmaceutical, and nanotechnology sectors. Debodhonyaa is proud to have graduated from Miranda House, University of Delhi, with a BSc honors in chemistry. She then earned her doctorate from Cornell University, also in chemistry, and her JD from George Washington University Law School. We start our event with a disclaimer that please note that today's discussion is not designed to provide legal or other advice, and the audience should not take or refrain from taking action based on today's discussion. With this, I hand it over to Debodhonyaa for a small moment.
So good afternoon, everyone, and namaskar. Thank you, Neer, for that wonderful introduction. It is a pleasure to be here today to speak to our student audience. There's no better place than to start at the beginning, so let me tell you a bit about myself. I arrived in the US as a graduate student, just like many of you. I had done my BSc honors in chemistry from Miranda House, as Neer just mentioned. And then I decided to attend Cornell University for graduate school. Graduate school was a lovely experience, and Ithaca, New York is a lovely city. But during my graduate career, I realized that I was looking for something more than just being in academics. Patent law seemed an ideal fit for me because it combines the science with the law. I used the knowledge that I've gained through many years of my education and in my day-to-day work. And it is a good use of my technical knowledge and my technical degrees that allows me to keep in touch with science, but also explore a different career path. That's not to say that you have to be an attorney to build a career in patent law, and we can talk about that later during our discussion. There are other careers related to patent law that many STEM students might be interested in later on. I've also been asked briefly to talk about intellectual property law in general, because that may be of interest to some of you because you're in the STEM fields. There are 4 main categories within the IP umbrella, the intellectual property umbrella, and the 4 categories are patents, trademarks, copyrights, and trade secrets. Patent law is what most people are familiar with, and patents are used to protect new and useful ideas. For example, the light bulb, or a pharmaceutical composition, or the TV that you watch. All of these can be protected by using patents. Trademark is a different kind of IP protection that is available, and it protects the names of goods and services. For example, Kodak, Xerox, these are all trademarks that have now become part of our language, but they're actually trademarks, and it protects the name and protects the goods and services that have that name. The third category is copyrights, and that protects original works of authorship. For example, if you write a book or you publish a paper, you write a song, all of these can be protected using copyrights. The final category is trade secrets, and this protects information that is not known by the public. It's something that companies hold very close to their chest. And the most well-known example of trade secret is the Coca-Cola formulation. Everybody knows it exists, but nobody knows what that formulation is. There are some other categories such as trade dress and know-how, which also fall under the big IP umbrella. But the four main categories are the ones that I mentioned. Of all of these categories, patent law is the only one that actually requires a technical degree, particularly for prosecuting patents. And what does prosecution of a patent mean? It's not, when I say patent prosecution and prosecutor, people automatically think of a criminal law case where there's somebody representing the government and he's the prosecutor in a case. But that's not what we do for patent prosecution. Patent prosecution is a term of art where we help the inventors to take their invention from a simple invention disclosure that they put together when they think that they have something that is unique, and we discuss the invention disclosure and their ideas with the inventor, help them draft an application. We file that application with the patent office. Then the patent office gets back to us to say, we don't think this applicant deserves a patent for XYZ reasons. And then there's a back and forth conversation with the patent office with people that are known as examiners. They also have a technical degree, but they work for the government. And then there's a conversation with the examiners at the patent office where we explain why our client's invention does deserve a patent. And this process continues until a patent is issued. So that, in a nutshell, is how patents work in this country. There are three different types of patents. The first are known as utility patents, and this is the most common type of patents. The name itself indicates what they protect. They protect things that have utility, protect structure and function of a product or a service. For example, as I mentioned, electronics or mechanical devices, pharmaceutical compositions, optical instruments, these are all things that are protected using utility patents. The second type of patent is a design patent, and that protects ornamental features of a product. Example, sneakers or handbags or machines. If the client wants to protect the design of the machine, not really what it does. These are things that are protected by design patents. And then lastly, you have plant patents, which protects asexually reproducible plants, but this is not a very commonly filed patent application in the US. It accounts for the least number of patent applications. So that, in a nutshell, is what the patent system is generally. And I'm looking forward to our discussion with Neer and Gaurav.
Great. Thank you, Debodhonyaa. This was a great information. I mean, I think a lot of us have like a very minimal idea in the STEM field, at least. So I think your insights are really helpful to understand and integrate future careers that we go forward to. With that being said, I think we can go with some of our questions and.
Okay. So the first question for today is, what are some of the patent law related career options available for STEM students? And do I need to have a law degree to start with?
Great question. So the most common answer, of course, is you can be a patent attorney like me, and that does require a law degree. And what that entails is after you finish your technical degree, whether it's bachelor's, a master's, or a PhD, you can take the LSAT, you can apply to law school, you can go through the 3 years of law school full-time, and then you graduate with the JD, and then you can become a patent attorney. Specifically, to become a patent attorney, you also need to take what is known as the patent bar, which is an examination that is administered by the U.S. Patent and Trademark Office. And it's meant to test your technical knowledge in the area of patent law and also in there are some requirements that you have to fulfill in order to be able to sit for the patent bar. So that's the first option. The second option is to do work that is similar to what the patent attorneys do, but without the law degree. And those people are known as patent agents. It would be a similar path where you graduate from either bachelor's program or master's program in a technical degree, and then you sit for the patent bar. As long as you meet the requirements for sitting for the patent bar that's administered by the patent office, you can take that exam, and then you can say that you're a patent agent, and then you can assist clients to file their patent applications. And the third area, if you have a STEM degree, is to work as what is known as a technical specialist at a lot of the law firms. Especially now, a lot of the law firms that handle intellectual property matters and patent law matters specifically will hire students that have STEM degrees, and they assist the attorneys and the patent agents in analyzing applications and helping the clients out, and they provide the technical knowledge that might be needed for a particular application. So that's a third option. And to be a technical specialist, you don't need a law degree, you don't need to take the patent bar. You can just work right out of your graduate school.
And all the whole spectrum of STEM education is represented. One can expect, or there are some sectors that are more represented than others, I suppose, and so on.
That's a very interesting question, because the simple answer is yes. Any STEM field, if you have a degree in any STEM field, you can become a patent agent, a patent attorney by taking the patent bar. The more nuanced answer is that, as I mentioned, the U.S. Patent Office has certain requirements that you have to meet in order to take the patent bar. So they have different categories of eligibility that can qualify you to take the patent bar. The first option is if you have a degree in the list of degrees that they have approved. And I think they have 32 degrees that if you have that particular degree, you automatically are eligible to sit for the patent bar. If you don't have one of those 32 degrees, there is a process where you can show that you have the necessary qualifications by showing that you've taken X number of classes in physics, X number of classes in chemistry, and so on. They have specific combinations that you need to show that you have the technical expertise to take the patent bar. A lot of this information is available at the USPTO website, so you can go there and get all the information, because it's been a while since I took the exam, but you can figure out the information to see, even if you don't have those particular degrees, how you can qualify to sit for the patent bar, as long as you've taken the required coursework. And even if you haven't, you can fill in the blanks by taking any classes that are missing to make up for that.
Yeah, thank you.
Yeah, those are great information. And just to follow up on that, you mentioned briefly about the categorical classification where asexual propagation and things like that are patented. I mean, it's just coming from my personal experience. If there are some invasive plant patenting, if somebody found it and they want to patent it through their like descriptions and like the life cycle and things like that, what categories does that fall in? Is that something common, like coming out from like pest pathogen, things like that?
So plant patents, as I said, are not very common, and they have specific requirements as to what is patentable or not. So if you're really interested, the best option would be to speak to someone who actually deals with patents who deals with plant patents on a daily basis. It's not something that I do on a regular basis, so it's not something that I could give you advice on. But it's a very unique category with very technical requirements of what can be filed as a plant patent application. So, but it does exist, and people do file them, and it's a big, it's possible to do it.
Thank you for the information. Let's go to our next question, so do we need to have any basic knowledge of patent law to take the patent bar? I know you highlighted a lot about like 32 disciplines and stuff, but what are the basic knowledge to take the patent bar?
So the patent bar actually does not test your technical knowledge. what the patent bar will test is a basic understanding of the patent laws, of US patent laws. And what we use is known as the Manual of Patent Examining Procedures. We call it MPEP, that's how we refer to it. And the patent bar exam essentially tests your knowledge of the MPEP. And if somebody is interested in taking the patent bar exam, there are professional companies that have tutoring classes that will take you through the process and give you the information that you need to take the patent bar. I believe it is a 6-hour exam with 100 multiple choice questions, but you can prepare for it. It's not something they will test you without giving you the information that you need.
Yeah.
Okay, then I'll ask the next question. So, as STEM students in the US, what do we need to know about the national patent laws and our rights as inventors and researchers?
This is a very broad question. So each situation is unique. Each STEM student is unique in terms of the research that they're doing and which universities they work for. Usually universities have their own rules that govern who gets to be an inventor in an application and things of that nature. Generally, like a 360, like a very high level view, it would be that most universities will own the patent because they will become the owner of the patent that comes out of any work that is done at the university using university resources. But if you have any questions about inventorship, the best thing to do is to know people in the tech transfer office, because most universities, I would say all universities, have a tech transfer office that have patent lawyers at the offices that can advise you. So that would be the way to go about it. The most important thing to know, and this is generic information, is that the US is a first to file system. We used to be a first to invent system pre-2013, but now we are a first to file system. So it's important, if you think that you have an invention that is worth patenting, it is important to be timely in filing that patent application. And then also figuring out the inventorship of that invention, who actually came up with an invention, is something that you need to be aware of. So I hope that helps. I know it's not very detailed, but like I said, every situation is so unique, you can't really address it, but I wanted to give like an overview of the process.
Oh, yeah, that's really great to know. I mean, about the patent lawyers that we have in our universities. And so I'm really intrigued about like the expenses. Like if a student wants to, I mean, from a student point of view, if somebody wants to like get started on the process and initiate it, is there like any starting cost they have to incur, or like what is the extent of expenses they have to think about?
Sure. So as a student, like I said, each university has their own tech transfer office. And usually, again, I can't speak for the universities, but usually they will handle the patent filing and all of that. If you feel that you have invented something, say you were sitting at your house and you came up with this brilliant idea and you think it's an invention that has nothing to do with the school, and you want to file the application yourself, then the government has some filing fees, search fees. It's a few $1,000s. All of the information is on the Patent Office website. The Patent Office allows you to handle your own application if you wish to. You can do the whole process yourself without hiring an attorney. If you feel that you have enough knowledge, you can learn enough about patent law yourself, inventors are allowed to file their own applications. But if you don't have the technical expertise, it becomes a little difficult to have that back and forth conversation with the examiners at the Patent Office to really explain why your invention deserves a patent. So that, of course, involves attorney fees, and depending on how complicated the process is, the cost can vary. But if you really feel you have an invention, you definitely should speak to someone who knows patent law and can guide you through the process.
Thank you so much for the information. And so, I mean, about the uniformity, like all across the world, are patent laws the same across the world, or can one patent be used to enforce rights across the globe? I mean, uniformity is an issue in all the disciplines, like especially like yeah, even with the units while driving in the United States and while in India. So that's something that's a great question, I think, but by somebody.
Yes, unfortunately, each country has their own patent laws, and enforcement depends on the jurisdiction that you're in. There's no uniform single patent filing system for enforcement across the world. The closest that we have is what's known as the Patent Cooperation Treaty, where you can file one single application, but once that application is filed, to have a patent in every single country that is part of that treaty, you have to file what is known as a national phase application. So even though you're filing one application, you still have to go through the patent prosecution process in every single country. So it's not really a single patent that will work everywhere.
Okay, and so this is the next question is something that really flows into your answer here, and this is from Varun. What should we do if someone is infringing on our patent rights, and or if we are contacted by someone claiming that we infringed on that patent and so on? So maybe you can answer this, be specific, more specific about the laws in the US in this case and so on.
That actually has a very simple answer. If you think you have infringed on someone's patent, and or if someone sends you a cease and desist letter or something like that, talk to an attorney. That is basically the simple answer. You need to figure out whether there was an infringement, and if there is something, what is the extent of the infringement, and what are your remedies. It's all something that you would need to speak to a patent attorney or a patent litigator for that.
Okay. Thank you. I think that's something important we all need to know, specifically in the STEM field, if we are patenting something and there are like several research that gets replicated in the other part of the world and nobody has any connection to that, or so that's really important. So coming to the next question, I think for a lot of like viewers and attendees, you are an inspiration here with the transition that you made from like a from a STEM grad school and then into a very different field, but really an important field for all of us. So yeah, why did you decide to switch careers? And rather, I would put it this way: how easy or how difficult was it for you to transition the career from one field to a totally different field?
Thank you for that question. Why did I move? Well, as I mentioned, I quite enjoyed my graduate school career, but I was in a unique situation where the type of science I did enjoy doing it, but it meant that I was stuck in a basement for 5 years of my graduate career because it was a lot of optics and PChem. We needed vibration isolation tables. It's a long story, but I figured out very quickly that I wasn't really suited for a full-time career in academics for the rest of my life in the field that I had chosen. And patent law, as I mentioned, seemed a great fit where I could still use my technical expertise, but it would be in a different field. And law also appealed to me because I'd always had an interest in the social sciences through, schooling in India and so on. But I felt that I never got a chance to explore that part of my interest. And patent law gives me a bit of both. It helps me keep in touch with my technical side and also gives me a chance to write more. And that's been a great option for me. In terms of how difficult or how easy it was, everything has pros and cons. So you have to figure out what you're interested in really. I will say that being a lawyer is very different from being in academics and being in graduate school. It's a very different life with different requirements, your day will look completely different than what it is in graduate school and in academics. So that's something you have to take into consideration. in terms of switching from science, from graduate school and a career in academics to law, once again, it is a little tricky because you have to get additional training, especially if you want to be an attorney, then you have to go to law school and do that part of the requirement. So it's not easy, but it is possible. I hope that answers your question.
Yeah, totally. I mean, yeah, from manuscripts to legislation. So, I mean, yeah, that's totally inspirational for a lot of people.
And
Yeah.
so we now have a question from the audience, and this question has a touch of philosophy to it. It's really putting you on the spot now. And so, what do you feel about the concept of intellectual property in general? Do you think knowledge should be open for all, or do you think intellectual property is needed and it's a force for good to maintain balance and so on? This is a question from Kasturi.
That is a very loaded question, and yes, it is a very philosophical question. I don't know if I have a specific answer for Kasturi. What I would say is I tend to look at things from both sides. So yes, intellectual property should be available to all. You know, if there's a new invention, yes, people maybe deserve to have access to it. But on the other hand, companies that are producing that intellectual property are putting in a lot of resources into coming up with that invention. And it doesn't happen overnight. There are a lot of failed inventions that result in something that is patented. So it's a long process. Sometimes it takes decades to come up with an invention. So, you know, there has to be an incentive for those companies to come up with inventions. And if they cannot get a patent, or if the patent system doesn't exist, then what would be the motivation? In an ideal world, everybody should be philanthropic and just do it for the good of the greater world, but that's not how things work in the real world, unfortunately.
Yeah, thank you for the answer. You had
yeah. Thank you, Debodhonyaa, for that. I mean, I'm curious about, I mean, since you came from like STEM's background, I mean, so most of the grad students coming into research, they're pretty inquisitive about things, and like they have minds that can like definitely bring innovation. So what are your perspectives about the gap between the information that's on IP that's not being provided to the researchers in their like early phase? And do you think like if it's provided, will that be a motivation for the grad students to be more innovative and have something of their own and put the name to it?
Thank you, Gaurav. That is a great question. And that's something I think the IP field in general has been contemplating for a while, because I don't know how familiar the audience is with the legal system of the US, but diversity is an issue. We are not a very diverse profession, and IP law especially is not very diverse. So there is interest in increasing the numbers. And you're right, you're absolutely right. Providing information about the patent system or the IP system in general would be a great initiative to get more people involved. Even when I started, I really had no knowledge about the patent system or the IP system when I was in graduate school. And it just happened by chance that I fell into this career because I knew someone who who worked at a law firm, and that's how I came into this career. So you're absolutely right. You hit the nail on the head in terms of providing the information that STEM students need to know what is available to them, and also to increase interest in being a part of this world, the IP world.
Yeah, I totally agree with all that you said, because I mean, probably this is the most like after coming to the United States, this is the most I'm having the discussion on IP with someone. So, but yeah, Neil, do you want to follow on the questions?
So we're getting new questions, and so there's a question in general about again slightly philosophical, but now focused on medical intellectual property and so on. And what are your so the whole question is not here right now, actually. So But really, I mean, any comments about medical intellectual property? Do you think it should be shared more freely, or there's reform needed in the area? And I mean, this is of course a political topic too. I mean, in a very deep sense.
Yes,
Yeah,
yes, it is. And so I will refer back to my previous answer, which says that, you know, both sides have a pretty good story to tell. And I don't know that we can fix the problem, or if there is a problem today. So it's something that needs a more in-depth discussion that we have time for today.
Of course.
Yeah. Yeah, we have limited time, but I think there's an interesting question from Deepak, and says, can I take any preemptive measures to protect my expected patent in case I believe that my research is nearing to discovering something new, which I would patent?
So there's one option available, which would be to file what is known as a provisional patent application. So the provisional patent application is something that inventors file sometimes when they don't know if they have finished all their research. And the provisional patent application is not published. It's just sort of, as the name says, it's a provisional application. And filing the provisional patent application gives you 1 year by which to convert it into a real application, which is known as a non-provisional application. It is the non-provisional application which will be actually examined by the patent office. So the provisional application is sort of placeholder, which gives you a year to figure out if it's something that you want to move forward with, or if you have additional data that comes out through your research between the time that the provisional application is filed and the 1 year date where you have to convert it, then you can file additional provisional applications within that period and then consolidate everything into one non-provisional at the 1 year date from the first provisional patent application. I know that sounds a little complicated, but it's not really a very complicated process. And if you think you're in a situation like that, again, talk to someone who's working in the IP field, whether it's the tech transfer office or whether, you know, it's hiring an attorney to look at your inventions. But that in a nutshell is one possibility that you have.
Yeah, thanks for the response. I mean, that's just a follow-up on the timeline. You just mentioned a little bit about the timeline and stuff like that. So is there any difference in like patenting in the timeline for like non-life sciences and life sciences patenting?
No, the patent, the time for filing a patent application is the same across all of the fields, such as electrical, mechanical, chemical, biological. It's all the same. There's no difference in the timeline of filing those applications.
We have an interesting question from Salma. Can I obtain a patent and keep my invention a secret?
That's an interesting question. Again, this is a very unique situation, and it would depend on what you're trying to keep secret, but there are some provisions where you could keep something secret. But generally, all applications are published for the public to look at once you convert the provisional application into a non-provisional application, as I mentioned. So yeah, there are some situations where you could keep it secret, but generally you have to publish it once you file the application. If you really think you have proprietary information, then one thing to consider is whether you have a trade secret. And that's a whole different area of IP law that you could look at and talk to someone who deals with trade secrets to see how you would protect that. In which case there is no publication to the public. But there are options, but it depends on every situation.
Yeah, there is a very interesting question from Praveen, and I think a lot of us will be interested to learn about this, and it's something new. So Praveen asks, can I patent softwares? I was told it is not possible. Why? Isn't it an invention as well?
Okay, so disclaimer, I do not do software applications. I will not touch it with a barge pole because I don't understand software or computers. But yes, there is a way to protect software. If you're writing a program, you could protect it by copyright. There's a whole area of business method patents and software patents that is very nuanced as to what type of software can be patented, what you have to show. So that's something you would really need to speak to someone who is an expert in that area. I am not, sorry.
Yeah. Probably just to follow up, I mean, you don't really have to answer it, but do we like, for example, we write codes for like, for example, geostatistical modeling in agricultural sciences or something like just a code in any software. Can we patent those codes? Or is that?
Yeah, so if you're just writing code for a mathematical operation, then not really if you're trying to patent that mathematical operation, but if you're trying to particularly patent the code, maybe, again, we would have to talk about what you're trying to patent and see if it fits within the parameters of what is allowed to be patented. So there are certain categories that are allowed, that you can get a patent on. And there are some that you can't, such as abstract ideas or natural phenomenon or laws of nature, those kind of things you can't get a patent on. So it would depend on where your code falls into in that range of what is allowed and what is not allowed to be patented. So it's again, it needs a lot more discussion.
Thank you.
So another interesting question. Now, this is a question in history, actually. So this is from Kalong. When did patents and so on start as a concept? And is it a recent development globally, or and so on?
No, it's not recent. It's very old. I think the earliest patents are probably from the 1800s, late 1800s, early 1900s. I'm not really sure, but it's existed for a long time. Okay, maybe not that far back, but it has been around for a long time. Unfortunately, I don't know the exact number of years, but it's a very established field. I think people are talking about it more in recent years because the world has sort of transformed into a global village where people are transporting their inventions across borders, and there's more awareness of what should be protected and not protected and so on. So the concept of patents has existed for the longest time. And the origins are actually in old English laws, where you actually got a patent for a piece of property. And then that's how it all sort of transpired. From there, we are here today in the modern IP world, but it's been around for a while. But it's just, I think there's more awareness now because people are becoming more aware of things that are being protected and the politics of it all.
Great. Yeah, I think there is an interesting question and pretty much a follow-up from what you previously answered about your transition from STEM to the law field. I mean, for any audience members who are interested in making the switch, are there any preparatory classes or information that they can look up to ease the process, or any basic courses that they can at least take, and alternatively, like any mandatory courses that any like researchers should know about, or like in different department or something like that?
So I don't know that there are any mandatory courses, or let me rephrase that. There are no mandatory courses that you have to take. If you want to transition from being a STEM student to a career in patent law, then I would recommend that make friends with your tech transfer office people to get an idea of what the work it entails. If you have a law school on campus, see if they offer any IP classes and that you can audit. Sometimes you can get an idea of what IP law looks like if you do that. Another great opportunity would be to see if you have a bar association in the city that you are located in. Bar associations are generally voluntary associations for lawyers, and I am part of the South Asian Bar Association here in DC, and there are SABA chapters all across the country. There's also SABA North America umbrella group. So you can always contact them. They usually have student members, and of course, those are law student members. But if you reach out to them and say you're interested in transitioning and you would like to speak to someone who is in the field, then I'm sure they would be more than happy to connect you with people who are working in the field to get an idea of what you might need. But as I said, you can become a tech specialist without doing anything, just applying for jobs that are looking for tech specialists. And then if you want to be a patent agent or a patent attorney, you have to take those additional steps of taking the patent bar and or going to law school. So, hope that helps.
Also, the Saba that you mentioned, do they have like any social media connections where like people can get connected to them, or are they like open to connection for everyone, or is that a closed group, or how people can get connected to this?
I think all Saba groups work independently of each other, so I can't speak for all Saba groups, but it's not a closed group per se. They are meant for lawyers. So, you know, for example, Saba DC has membership categories for law students, attorneys, etc. But we also have a category known as Friends of Saba DC, where you don't have to have a law degree to sign up for the newsletters to get the information that we are distributing. And social media is everywhere. All Saba chapters have a social media presence, so you can just Google and find your nearest chapter through the websites.
Thank you.
Okay, we have another question from the audience. This is from Binny Thomas. I'm not a US citizen, and nor am I a green card holder. I'm an Indian citizen. Can I get a patent in the US? My friend told me that only citizens and legal permanent residents can get one. Is that true?
No, that is not true.
Mhm.
You can get a patent even if you're not a citizen of the US.
Mhm.
That's a simple answer. Yeah.
That was
You have to declare your citizenship. So you have, I mean, there is, when you file an application, you have to put in the inventor information. So they ask for your address, your citizenship, they ask for all of that information. But it's not limited only to US citizens.
Great. Yeah, and there is an interesting question from Atharv, and it says, if I invent something while working for a company using my own resources and time, is it mine or the company's? If it's the company, if it is the company, can I do anything to keep my rights? And I was curious when you mentioned about like the university, if you make a research through university or individually, is that universities like, or how? Yeah, that's a very interesting question. How an individual can keep the right if it's filed through a company or and university.
Again, this will depend on specific situations and what your agreement with the company is. You know, every time, all companies, you have to file an employment, you have to sign an employment agreement. So it'll outline what rights you have, what rights you don't. Again, if you have any questions, you should reach out to an IP attorney to discuss any concerns that you might have. But generally speaking, and this is very broadly speaking, if you're using the resources at a company or at a university, generally they tend to keep ownership. You may still be named as an inventor if you are the one who came up with the invention, but the ownership rights might belong to the company or the university, depending on the situation. So that's the easiest way to answer that question without going into too much details, because as I said, each situation is different for each individual.
So, and when you said like about agreements, so just being aware about it, because I'm like transitioning to different job opportunities and stuff. So when we sign a contract, is there like anything mentioned about a patent in it, or like the beginning that we need to be careful about in reading? Or
again, it will depend on the individual contract that you are given. You know, some contracts do, some contracts don't. It depends on what the policy is. The first thing they teach you in law school is never sign something that you haven't read thoroughly and that you understand thoroughly. So no matter which field you are in, when you're signing a piece of paper, always know what you're signing. You know, that's the easiest way to put it.
Yeah.
And if you have questions, always ask. You know, if you really think that you have an invention or you might have an invention, talk to the people that you're negotiating with to see what is available and what is not. It's a conversation that you need to have depending on what your interests are.
And so the next question, I think you already sort of answered in passing, but I think it would be nice to have it concretely answered once again. And so this is from Ria. What kind of concepts are not patentable?
Oh, okay. This is things that are not patentable is very briefly are abstract ideas, laws of nature, any natural phenomenon. For example, anything that exists in the nature, you can't claim a patent for it because it already exists in nature. It's not your invention. So that's what the Patent Office tries to avoid issuing patents to. So that's what's not allowed. This is a very, very nuanced, complicated issue because what we call Section 101, what is patentable subject matter, it's actually been litigated in the courts. So there are very precise ways in which you have to show why even if it does include a natural product that appears in nature, how you can get a patent for it. There are ways to do it. For example, you can tie it to a machine that is using that, or you're combining it with something else that does not appear in nature, or it's a very nuanced topic in terms of what is and what's not patentable, especially in light of all the case law that has come up. But there are some things that are not patentable in the Patent Office.
Okay, we can go to the next question now.
Yeah, there is an important point raised by Arunanshu. If I shift to India after getting a patent in US, will my patent be still protected? Will I need to defend it in US courts only?
So US patents are only enforceable in the US. So it doesn't matter whether or not you are in the US. If you file a patent application here and that patent is granted, it is enforceable. And it's enforceable for a fixed period of time. And then it expires. So patents are not indefinite. So if you get a patent, your invention is not protected for the rest of your life. There is a fixed time period. But it doesn't matter whether or not you are physically present in the US, your patent will still be enforceable. But in order to enforce the patent, you will have to hire attorneys that work in the US, and you will have to work with them in order to, figure out how to protect your invention. But you don't need to be physically present here.
In that case, I just wanted to learn, about the time that you mentioned, like your patent is like, there's a timeline, the patent is there, and then do we need to renew it, or like, how does that work?
No, there is no renewal process. So you get 20 years from the date of filing of the patent. So you get a patent for 20 years.
Oh, okay.
Yes, sometimes that time may be extended if there were delays in the patent office, or there's a patent term extension if the FDA, for example, for pharmaceutical composition, if the FDA approval process took longer than expected. There are some ways in which the patent term can be extended, but generally it's 20 years from the date of filing of the patent.
Yes. So maybe we have one last question that we can take from the audience. In the meanwhile, I'll ask some sort of a socio-emotional question. Okay. So we're covering all fields here today. And so, people coming from India traditionally now for many generations have now looked upon as having strengths in some of the traditional STEM fields, right? Like engineering, medicine, and so on. But even within STEM and outside STEM, there are many fields that it's not still that Indians are well known to be very successful and so on and so forth. And it can be a little harder than to sort of achieve things there and so on compared to achieving things in engineering now, right? You almost have positive bias if you're an engineer now and so on. So did you face something like that, or general advice on that, how to go through that? You've been here a long time and you've probably seen the culture change here in the front of your eyes and so on. So just a very vague question.
No, it's a legitimate question because, first of all, we come to a different country. So you have to acclimate yourself to a new country. And then if you want to be an attorney, it's not something that we're exposed to, growing up in India. You know what they say, Indians are always either engineers or doctors. And then if those two don't work, then maybe you're a lawyer. So it's difficult in the sense that there's not a lot of representation of people who look like us in the legal profession, especially at the higher levels of partners and executive board members and so on. So in some sense, you have to be the trailblazer. You have to make your way up the ladder and be proactive in doing it. It's possible. It's not impossible, but yeah, it takes a little bit more work to get noticed and to get to where I am today. It did take work. It wasn't easy, but if you're patient and you keep at it, as you know, we are known for just doing our thing and keeping at it. So it's possible.
General advice on how when we can sell ourselves where we don't have this sort of a positive bias associated with our communities and so on. And
I think it's if you're interested and you want to make a career in something that is not a career where we are very prominent in, and it's not just law, even politics, for example, in the U.S. there are not a lot of South Asians.
The arts and so on.
So any kind of career that you choose, if you're not if it's not such a common career for people like us, then it's just you have to show interest and you have to learn what makes people tick, what makes people a success, and you have to sort of build yourself towards that over time.
And that is something people should keep in mind, right? Because if when we shift from STEM to such a field, we might get a little bit of shock, right? And so on. And
yes.
And so.
But it, like I said, it's possible, and I'm not the only one. There are now, over the year, I have been doing this. I've been in the law for almost 15 years. It'll be 15 years next year. When I started, there were fewer people who look like me, but now there are a few more. So the numbers are building. So we're looking at the next generation to build the numbers even further as time goes by. So.
I think that's so important because when we come from a different country, and then we already are in a different culture shock initially a little bit, and then that adapting and then thinking about a new field and then exploring it and then another shock there. So, but I think that was a great response, Debodhonyaa. I think we're getting close to time, but before that, I would like to have one final question, just a very generic question, more like, what will be your piece of advice a final piece of advice for early careers or students in the STEM field or in any field who wants to transition in the law?
For STEM students who want to transition to the law, the first thing I would suggest is getting to know people who are in the law so that you can get an idea of what that life will look like, because it's so different from academics and what we're used to. Before you make the transition, you should figure out if that's going to be a good fit for you. And if you think it is, then go for it. Start as a technical specialist if you want to see if it's going to work for you. Then, that's what I did. I started as a technical specialist, then I went to law school. So if you want a career in the law, there's nothing stopping you. You should just go for it and see where it gets you.
Great.
So we just got 2 more questions from the audience and we want to just quickly answer them. Is that okay? Let's do that. And so there's one from Akansha. She says, I believe my discovery might be used for nefarious purposes. Can I file a patent on my invention without disclosing the important aspects of my invention? I don't want anyone to use it for malicious purposes. And so quick answer, maybe. Yeah.
Quick answer is, as I mentioned, trade secrets is an option for you, and patents and trade secrets generally go hand in hand. Where patents, you're disclosing something about your invention if there are unique aspects that can be patented, but there are some things that you're holding close to your chest in terms of a trade secret if you really don't want to disclose that. Again, This will take a little bit of finesse and discussions with your patent attorney to figure out what aspects are patentable and can be disclosed, and which aspects you want to keep secret. So it's possible, but it'll take a little bit of discussion with your patent attorney.
So one last question, maybe Gaurav, yeah?
Yeah, so I think you partially answered this question before, but it's like pretty much an extension. But so if rules and benefits are different for filing patents in different countries, should I think of filing patent in some other country, say in Europe, where I can get more benefits? Will this be enforceable in US under any conditions?
No, patents in individual countries are only enforceable in those countries. That answers that question. In terms of where to file, it's a business decision. A lot of companies will figure out where the market is for the invention, and then they will file in those countries. Or if they have a presence in different countries, then they will file in those countries. So generally, it's a business decision as to which countries the patents are being filed in.
Okay, so I think that ends the questions and discussion part of the program and also the program. But I would like to thank everyone, including Indian Student Hub, for organizing this event. All people for attending. Great questions. Thank you, everyone, and special thanks to Debodhonyaa for being so personable, precise, and just awesome in general. And this video will be posted online on the Indian Student Hub websites and so on. But for now, a very goodbye to all of you.
Thank you, everyone.
Yes.